for being spoken on yesterday, pleased to discuss the discipline 1359 of 2016 law with liberty to the state government to take action in accordance with law. On the report of the local Ayuktha under section 12, that would be fortunately allowing the discipline for the reason that the
I don't know. Want to being spoken to means what you who will be filed on what being spoken. Where is the memo?
Yes.
What is the procedure like? We will consider it tomorrow. All right, tomorrow. Yes.
Commission going memo. Appeal. Right of interim order passed by Honorable Court. The government has formed the committee and appointed the member and also please stop me.
Are you asking us what is your remedy? No, are you asking us what is your remedy? Should we advise?
We memo for tomorrow. Where the necessary application to.
No, if something has been done in violation of interim order, then that is contempt. File contempt petition.
That's why necessary application in this petition itself. And tomorrow, we have formed the committee member by appointing the committee members.
File a contempt. We are not sitting here to advise. No urgency, right? Recalling, what is the urgency? I mean, they don't appear when the cases are listed. Then what is the urgency?
What is the urgency, Mr.?
Urgency we are asking. What is the date? Why it was dismissed? No. Why your petition? You are seeking revival means it was dismissed, right? Huh? And has he filed? So he wants final hearing. Tell him that it's not done. Not admitted as yet. It will be admitted day after. Or tomorrow. Why day after? Tomorrow. Then how you are appearing? You are not. Form C. When you will get, then mention. You can't be permitted to appear like this. Return it. Get the Form C and then mention. What? 2 weeks, failing which appeal shall stand dismissed without reference to bench. Failing which appeal shall stand dismissed without reference. 3 weeks peremptory. 3 weeks peremptory. Memo for service of notice on respondent is accepted. In leave. Memo taken on record. Appeal is dismissed as record.
Link. A, B, D and B appear.
Dismissal of appeal against R5, C and A.
During court.
Right? Yes. Peremptory order. In view of peremptory order dated 29/11/2022, appeal against respondent number 5, C and D is dismissed. What about this thing? 3, 4, 5, 3, 4 and 6. You are appearing for 3, 4 and 6.
5A, B and D.
What about 3, 4 and 6?
3, 4 and 6 notice has not been ordered.
So issue notice to respondent 3, 4 and 6.
7. Is another. Next month.
Huh? Not here, madam. Yes, learned counsel for respondent praise warrant is granted. A week's time to enable her to file objections. To IA, 1 of 20. 1 of 20. All right. So list tomorrow. Undertakes to file the objections during the course of the day. Let the IA be listed for consideration tomorrow. She can appear through video conferencing, right? Not a big thing, right? Maintenance only. We are not asking her to argue about reconsideration of either Keshwanand Bharti or somebody like IR Kolo's case. Not like that. Maintenance. You know what is.
Number 8. Is the third.
Weeks, peremptory.
Number 9. It is the state.
Yes, Mr. Is on behalf of respondent. And Mr. Is on behalf of respondents is accepted by learned SPP, SCGP. SCGP. The case one is granted. This is EPS corpus. What has happened? Petitioner's daughter is missing. Daughter. Please. They say office objects should be complied with within 3 weeks. Oh. Restitution of conjugal rights is the remedy. Restitution of conjugal rights. Instead, you have filed EBS corpus. He has taken her away. She come and tell us. Whereabouts are not known. She is safe and secure with her father. Restitution of conjugal rights, right? Restitution. So you can produce, right? She's resident of Bangalore only. No. Kolar. What I mean, part of Bangalore only. So, learned counsel for respondents accepts notice on behalf of 124, issue emergent notice to R5, list day after. Day after the notice. 6. You can serve so and so 124 shall take steps. Or learned counsel shall take steps for service of notice on R5. List on whatever day after 16. And what about office objections? 13. Huh? Shall comply, undertakes to comply with office objections. In the beginning, you write. Yes. Yes. Ah. Ah, yes. Yes. Where is Mr. Gyanchinappa? Ah. So, okay, what next date? We had adjourned it on the last date of hearing also. If he doesn't have time, then we will appoint somebody else. If he doesn't have time, last date. Tomorrow, before vacation, Mister, not beyond. Huh? Who's that? So held up means
Then it can be produced tomorrow. He has received it.
tomorrow. Mister. Yes, Mr. Reddy. Learned Mr. Lakshmi Narayan, learned commit advocate prays for adjournment on the ground that that learned amicus is not available. List on December 20. Ask him to be present, Mr. Not like this. Don't take this lightly. It's a public interest litigation. Maintenance. So, how much was being paid by the family? Was there any maintenance fixed, quantum of maintenance fixed by the family? That's all right. What are you doing? Huh? Your client. You are the husband, right? What were you doing? Nothing. No, but she's your legally wedded wife as on today. Huh? No, this all oral submissions. Otherwise, we will pass an order. Have you filed objection to this item? Then you don't file objection. We will take it to be correct. You are arguing. It's not by invitation, Mr. We don't invite anybody to file objections. It's your choice. You are not filing an application. This thing, objection, we will consider the averments to be correct. 2019 is doesn't know.
File is given by some.
Yes, Mr. What is this? Some other file you have given? 14. Huh? And we'll read it. His condonation and it's saying maintenance. And he doesn't want to file reply. So we are thinking what how much to be granted. Appellant was working in HAL factory, salary of 40,000. 10,000. Correspondent. Waiting appearance of the council correspondent hearing is deferred.
Number 30, Narayana, Satish Kumar.
Reasons assigned duly supported. Delay of 6 days condoned is allowed. Admitted for hearing. What stay, Mr. Dismissal. No orders are required to be passed on IA 1 of 2018 as the petition filed by the appellant seeking dissolution of marriage has been dismissed. Accordingly, IA 1 of 18 is dismissed. IA 2 of 18 shall be considered at the time of hearing of the appeal, then record.
14, Narayana.
The condoned IA is allowed admitted for hearing record. Same order 15. Delay of 15 days, 29. Admitted for hearing.
Number 16, the Lakshmikant case.
Delay condoned IA is allowed admitted for hearing record. All the cases record.
Okay. Papa is non-getting.
Ah, what happened? You have signed. Huh? So what happened? I mean, he has signed, right? Huh? Where is yesterday? Where is it? Yesterday? So, you have done it, right? Huh? Not done. Huh. 4B? What 4B? What front? Page 1? 4B. If PS print adult. Mention the name of the mother. Fresh one, he will do it. But we cannot issue passport to you, madam, in the embassy. Huh?
Should have printed the application and handed over.
No, you will give a fresh form this time. Will be rejected. Huh? Madam, this is not the, I mean, this is not the issue involved in this petition, right? Appeal. What happens eventually, what order we will pass? Against what order you have filed this appeal? We cannot issue a passport or visa to you in this we don't know. Yes, sir. We will hear you what is the 13, 12, 21, whether this order has to be set aside or not. And the prayer is to appoint you as guardian of my minor child. We don't know, madam. Please understand. We don't know whether it will be rejected, it will be accepted. We don't know. So he was telling us that he wants children to come to US. Probably that's the way he wants.
Yes.
Give one more this thing. When?
I
No.
called,
If it is rejected, then what happens?
I called US Embassy and they told me that write NA over there. Because she is not applying with her, she is accompanying her. The word is she is the adult applying. So nobody is applying with Anika. I have called and I have confirmed, and that's why I have written NA after talking to US Embassy in India.
You know it is rejected. We don't know. We don't know. We have not complied with this formality, so we don't know whether it will be accepted or rejected. What basis? And are we here to decide in this appeal whether what he should write in clause 4B is the question? What is the issue?
I have done it with the advice of US Embassy.
Please don't interrupt.
Sorry.
Huh? So he will give you want a fresh this thing, right? 4B. Write whatever. Whatever she says, you write and give it. What is there? You don't have any objection. Hey, this one. No.
This is the intent.
No, madam. You are traveling up beyond the scope of the appeal. We are no. This is not. No. This is not the scope of the appeal. What is it? We don't know what will happen. We are in this appeal. Something is going to happen. You take recourse to remedy which is prescribed to you in law, whatever. We don't know. We don't know what will happen to children. You should consult an astrologer. What will happen to them? Whether their future is bright or not. We can't decide this in an appeal. Then what will happen means? No. But we can't issue passport to you. You will appreciate, right? Can we issue US passport to you in this appeal? Whatever you are saying, I mean, can we issue? Then
Direction was to sign, he has signed and given.
Ah.
Direction you had sought is to sign it. He has signed it. That we don't know.
we don't know. You take action against that.
Your application was only to get the application signed. He has done it.
So sign the document for renewal. Yes, signed it. Now you are telling us that you are virtually rendering us to an appellate authority, that it will be rejected one day. Then we should we should decide that appeal and issue US passport to you. That's it. What is? We don't know.
We don't know, madam. That is not the scope of this application. signed, he undertakes to give another application.
Mari presence in compliance of the order dated 6/12/2022. The respondent has signed the document for renewal of passport. However, learned counsel for the appellant submits that the aforesaid document is not properly filled. In view of aforesaid submission, learned counsel for respondent has volunteered submit another set of document duly signed by the respondent within a week. Accordingly,
It's left to them. They want their.
we
You
can't-
give one more, that's it.
That
Whether
would
they,
get us involved in
whether
all
they
this.
submit it or not, that is for them to
We are
decide.
not an appellate authority, right? Very- what- Yeah. Acha, the application form duly signed by the respondent in original has been handed over to learned counsel for the appellate. That's all. So there are no orders, right? IA is accordingly disposed. IA, what is temporary injunction, Mr.? What was this IA? IA,
Yes, I for direction.
IA 1 of 20. IA 2 of 22 is disposed, right? Let pending interlocutory application listed after ensuing winter vacation. Huh? We don't know better what basis you are making an application. No, is there any IA, some interlocutory application filed by orally? I mean, just like we can't permit, right? Orally, I can also say so many things without being bound. We don't know, madam. This is not outside the scope of the. No, he has complied with the direction, madam, and is prepared to comply. He has said that he understands what is the meaning of this undertaking which he has furnished to us. No. That's the problem. That's the problem. You are unable to. That's why you want our direction. We don't know. Do whatever. File a separate writ petition. Do whatever that they are not doing. They are not granting passport, mandamus, seek mandamus. This can't be. Madam, in any case, we are not here to advise you. We have passed an order in your IA. In case you are aggrieved, it is file a SLP before Supreme Court. That's it. Dispensation. Requirement of filing the translated copy is dispensed with IA 1 of 22 is allowed. What is it, Mr.?
Dismissal petition.
Dismissal appeal is at hearing. Issue notice. Additional documents that will be considered at the time of hearing of the appeal. IA 2 of 22 shall be considered at the time of hearing of the appeal. Admitted for hearing record. You wear your mask properly, don't speak. COVID has not gone as yet. Wear the mask properly. They properly wear the mask. Why are you taking it off? Otherwise, senior along with corona will come here. Don't wear the mask. You have taken it. Not understood. Why have you taken it off? You should wear it properly. Like, see just behind you, how he is wearing properly. Behind you. It for you. So there is a stay. No stay. IA-2 of 2018. Effect of. Say the respondent is restrained from performing the second marriage if not already. 2 of 18 is disposed. 21 is notice. What is the point? That's all right. Upgraded to, we wish that it should be upgraded to municipal corporation in the next year when we reopen. But what is the point? Repeated. Years to correct the past cycle.
Filed by the Panchayat Development.
All right. What you have filed some memo? Memo? No, some memo you are saying it is upgraded to what? Municipal corporation?
Application.
Where? Oh, where is the application? Heard on IA number so and so. Application for amendment. Reason is taking into account nature of proposal. Allowed, let amended cost title be filed within 1 week. Then IA 3 of 2019 delay control IA is allowed. Let the appeal be listed for order of petition after ensuing winter vacation. Number 22. Appeal is admitted for hearing record. Counsel for the parties to jointly submit that there is a possibility of amicable settlement of dispute between the parties. They therefore undertake to appear before the Bangalore Mediation Center. Line below, in view of official submission, parties are directed to appear. Sixth of January 2022 at 3:30 in before Bangalore Mediation Center. Appeal is admitted for hearing. Record. Vacation. Effect of vacation. Appeal is admitted for hearing. Record. For hearing.
We are appealing to petition, my lord. 3797 of 21, my lord.
Ready?
We are the petitioner, my lord. My lord, we are already complained lodged to Karnataka police complaint being. My lord, we are the petitioner. My lord, we are already,
Issue.
Huh?
Yes, sir. He says that he was illegally. Please come to DG office. What is it, Mr.
my lord, we are already respondent number 5. My lord, already complaint lodged in police complaint wing, my lord, in page number 149, my lord.
Yes.
Already respondent number 5 is illegal activities purpose. We already complaint lodged to police complaint wing in enclose the page number 149, my lord. But those cases, concerned officer close the petition, my lord, and also further will give the complaint on Lokayukta, my lord. Please refer to, my lord, page number 228, my lord. Complaint ಬೇಕಂತ ಹೇಳಿ, my lord, close ಮಾಡಿದ್ದಾರೆ, my lord. My lord, already respondent 5 ಮೇಲೆ, my lord, complaint ಆಗಿದೆ, my lord. Page number 149. My lord, kidnap ಮತ್ತೆ ಹೆವಿ ಇಂಟ್ರೆಸ್ಟ್ ಮನಿ ಲ್ಯಾಂಡರಿಂಗ್ ಕೇಸ್ ಅಂತ ಹಾಕಿ FIR ಮಾಡಿದ್ದಾರೆ, my lord. ಪ್ಲೀಸ್ ನಾನು ಅದ್ರ ಬಗ್ಗೆ ಹೇಳ್ಬಿಡ್ತೀನಿ, my lord. ಒಂದು 10 minutes ನಾನು ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ತೀನಿ, my lord.
Please address the court in English.
Yes, my lord. My lord, one person is Krishna Prasad Vasudeva. He is one of the friend of petitioner. Petitioner going to Krishna Prasad office.
What is your grievance?
My lord, we are already complaint lodged to respondent number 5, police inspector lodging creating false FIR, my lord.
You want a case to be registered against this respondents 3 to 5
5, yes, my lord.
for offences under IPC.
IPC in Police Act, my lord. My lord.
For offences under IPC and Police Act, your remedy is before the court of magistrate, not before the Lokayukta.
My lord, already referred to Lokayukta, my lord. Lokayukta police, Lokayukta already closed the petition, my lord. And human rights also given the complaint, my lord.
Yes, they have, because you have approached the wrong forum. Your remedy is before the court of magistrate. That is why they have closed. You have approached the Human Rights Commission, you have approached the Lokayukta.
Yes, my lord. My lord, already police complaint being already complaint lodged to respondent number 5 and 6 and 7, my lord. You created so many documents, my lord. Because
Police not registered, the remedy is before the magistrate court, Mr.
My lord, magistrate court not accept the in police grievance. Otherwise, not accept my complaint, my lord. Also, we have given the police complaint wing, my lord. The police complaint wing is not fake information purpose. Close the this complaint, my lord. Please order, my lord. Once again, Lokayukta office, please refer to investigation report. Please order, my lord. Police, my lord, page number. My lord, page number, my lord, 226, my lord. Already order 226, my lord. In Lokayukta, one the order passed the dated 19/9/2020, my lord. Page number 226. ಪೊಲೀಸ್ ಪ್ರಾಧಿಕಾರವು ಕರ್ನಾಟಕ ಮಾನವ ಹಕ್ಕುಗಳ ಇಲಾಖೆಯಲ್ಲಿ ದೂರನ್ನು ಪರಿಹಾರವನ್ನು ಕಂಡುಕೊಂಡಿರುತ್ತದೆ. My lord, we are complaint lodged only human rights 13/5/2020, but Lokayukta court already 2019 year ಅಂದ್ರೆ ಒಂದು ವರ್ಷದ ಹಿಂದೆನೆ ಕ್ಲೋಸ್ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳಿ ಫೇಕ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಡ್ತಾರೆ, my lord. ಪ್ಲೀಸ್ ಆರ್ಡರ್, my lord. ಕರ್ನಾಟಕ ಲೋಕಾಯುಕ್ತ ಹೇಳಿ ಒಂದು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿಸಿ ರಿಪೋರ್ಟ್ ಕೊಡೋಕೆ ಹೇಳಿ, my lord.
Yes, we can. ಆಯ್ತು.
My lord, register the case, my lord. Investigation report ಕೊಳ್ಳಿ, my lord, ನ್ಯಾಯಾಲಯಕ್ಕೆ.
Yes, yes. You want us to register a case?
Waited for hearing. Expert. What waited?
So in section, the respondent is not at all married.
Not at all. You place it on record. Ex parte judgment, Mr. You are waiting, right? You are waiting, I mean, immediately 14 4, I mean, you got the bride within 3 days. 14th invitation expired, 15th, 16th and 17th, you got 48 hours, you got a bride, got married, everything. It is ex parte decree, Mr. Why were you in such a hurry? You will have to face.
January 2022. Appeal is filed in the month of February.
Appeal is filed in February, Mr.
May.
Is this-
They're doing.
It's filed on 23/5. This could say CL 23. Think the
What we. The directed to secure the record of the family court and this year orders on admission. He is remarried, is he? In the meanwhile, operation in effect of improved judgment and decree shall remain still. You should not have advised him. Should not have advised him. Let me this record stored on IA 120. Restitution of conjugal rights, wife subject. Restitution issue notice. How many more petitions, Mr.? When was the revised list published? You cannot upset the things at the will of at your convenience, right? When was the revised list published? No. Revised list, when was it published? Pushing you down. We didn't get it in the petition.
But 18/10/2022. 18/10/2022.
22. And when this petition was filed?
Petition of not something.
What were you doing nearly for 2 years, or 2 months, nearly 2 months?
Representation.
When representation was representation, when was it made?
22/11. Later that also was added.
22/11,
Please.
representation made. So that is also after 1 month.
And I was denied towards the, say, in medical notes.
No, but revised list was published, right? Pushing you down. You knew that this thing is still you are taking chance that let's see. You also play chess, right? Respondents play chess. You are what? Athlete.
Skating.
Here not
Huh?
Skating.
Skating. Yes, so we can't disturb the things Mr. at this point of time. We are not inclined to entertain on the ground of delay and latches.
Notes. Right, you need notes and get the class of it. Notes are actual notes and get it. You
When were you denied?
when I came to know that note,
No, no. When?
no, but
That is the
admitted
question.
notes, it is in number of it.
When? What date? Every day comes in these matters. You are just telling November, December, October.
Towards the pursuit of normal note, it's in section.
Date. Huh?
18 section.
8/11. Denied admission.
And the other student were.
Acha, 8/11 other students were admitted. So you have been granted a seat in BDS? No.
This case. 4 minutes. Half round minutes.
Around you have been allotted,
Half round minutes.
not allotted a seat.
Not allotted.
What did you do? Revised list was published on 18/10. You knew that you have been pushed down arbitrarily by Mr. Lakshmi Narayan. He's preferring chess players over instead of skating. What did you do? These are time sensitive matters, right? We can't intervene.
But the difficulty is not that there will not be other notes. See, what happens not is that there
No, what is there? Not a question of difficulty. Difficulty is about how to disturb the process of admission. You will be thrown out.
it's still not, it is not according to the rules. But they are not, they are under the rules, not then not found it is notes. We come to know that we don't even get the information notes.
What are the dates? Give us the dates, relevant dates. On when was the first list published?
First list notes, 2000.
So you were placed at what number? What number is
You are
that?
serial 13.
Serial number
13.
30. Thereafter,
13.
revised list was published on 18/10,
Please.
and you were serial number
18.
90. So thereafter, what happened? First round of counseling happened when?
Sports quota not. Sports quota not.
When was the counseling?
11.
Counseling held. Then what happened? Others were admitted on 8/11.
You're asking me to wait. Not the states which are granted.
Who asked you to wait?
Not the pay authorities. As if we expect. Paid representation is not the latest.
When did you-
representation is a connection here.
Your first point of time, when did you submit a
The earlier dates are notes, the annexes J, the dated notes 22/11/2020.
But these people have admitted they are prosecuting the studies, right?
Good. The
Huh?
upper promenade, is
No, no,
not-
no. These respondents have been admitted to the course and they are attending classes, right? Yesterday we were told, not attending classes, waiting for this petition to be filed. Huh? Not attending class.
Not complete only by 14. Section.
Even if they say that they are attending classes, it will not be. It's not complete.
Not com-
Half of the will conclude of
So,
the classes can begin only after admission process is over. Admission process is still on.
no, it's not correct. Academic session can begin.
And some of the colleges notes and
Yesterday we were told, right? These very persons.
respect of one college they say it has started. In respect of other two colleges.
What have you said? You have said not attending classes. What have you said in the petition?
That, but I. Only there was one institution where
Nothing otherwise turns upon whether or not they are attending classes. Fact remains that they have been admitted on 8/11/20, 1 month ago. Otherwise, if it would have been legal, why we would you have come? Right. So we are sure had it been legal, you would not have filed the petition. Obviously, it's illegal.
Illegal, not in accordance with the rules at all. So, if you have one medals, then participated in the. Not then.
Where from have you come? Yes. You are not seeking an adjournment, right? This is what is the yes? You are supporting the petitioner, right?
Yeah.
1 minute, 1 minute. Give us 5 minutes. Give us 5 minutes. We'll hear you. Yes. This petition has been filed by the petitioner seeking the following reliefs. Paragraph. Facts giving rise to filing of the appeal. Briefly stated are that the petitioner participated in the NEET UG examination 2020-22. The petitioner has participated in the state roller skate 34th state roller championship conducted by Karnataka Roller Skating Association. The petitioner applied under the sports quota for admission to NEET UG 2022. A revised list of the candidates under the sports quota was published on 18/10/2022, in which the name of the petitioner was placed at serial number 13. Thereafter, the aforesaid list was revised on 18/10/2022, and the name of the petitioner was mentioned at serial number 19. Full stop. Paragraph. Thereafter, a counseling was held on 6/11/2022 in respect of the seats for admission to MBBS course under the sports quota, and respondents 3 to 5 were admitted to the MBBS course to various colleges, two colleges, to undergraduate medical colleges on 8/11/2022. Thereafter, the petitioner submitted a representation on 22/11/2022, and this petition has been filed on 12/12/2022, seeking the reliefs supra paragraph. We have heard learned counsel for the petitioner at length. Paragraph in our considered opinion, the rate petition, the petitioner is guilty of inaction and has slept over his rights. Full stop. The revised list was published on 18/10/2022 when the cause of action had accrued to the petitioner. However, the petitioner, instead of approaching the court in quiet promptitude, has waited till 12th of December 2022 to file this writ petition. Full stop. Except for the petitioner has not done anything except submitting a representation on 22/11/2022. Full stop. The delay and inaction on the part of the petitioner in the facts of the case disentitles him to grant of any indulgence in extraordinary discretionary jurisdiction of this court under Article 226 of the Constitution of India. We therefore decline to entertain the petition. The same is accordingly dismissed. Yes. Tomorrow it's coming up. Everybody has gone now left.
No, we said tomorrow. Mr. Lakshminarayan said day after tomorrow.
So he told us that you have got all the information. He told us that you have got everything.
After tomorrow, he wants tomorrow.
You mentioned day after, right? Everybody is gone. We can't. Please appreciate. All right. So then tomorrow. The habeas corpus, what is there? Somebody's daughter must have run aged about 17 years. Okay. Yes. But you tell everyone. Yes, Mr. So we know everything about the case, right? Your junior must have told us, right? We have heard in detail all 7 volumes, everything. Yeah. What you are supporting the petitioner? No, not. All right.
Subject to result of the.
Yes.
Vision range, because vision range is two distributions and rental division 641. And another vision range. Cases stating that, holding that, the land acquisition can proceed if the land acquisition or beyond are required for acquisition. For the future, land acquisition is to and secretary conducted a meeting on 31 state land. All the universities. Go ahead. Meeting held on 31 9. PWD was taken by the land issue of 20th in his presence. We have taken more of how we letter of this, but
Which responded.
Therefore, the acquisition must go. Already been signed before the land. It's very clear, and this saying that we connecting land. To complete the connecting land, now we can turn plazas and everything that goes with the connecting land. Lands are certainly required. Actually, we not connected between the state is saying the appellants say the lands are not required. That may not be owned by the record given person. Secondly, sufficient extent is concerned. Let's
are in submitting the petition. Because assume that the state submission that the lands are not required is there. So ask myself only one question. Consequence of consequence would not be that the acquisition notification issued under section 28 must be caused by the government. Therefore, there may be other consequences, but that is not within the scope of this law. We are respect to submit. Acquisition notification. Respect. Suggestion that the lands are not required, or the state now doesn't hold it, the lands are not. Therefore, even assuming all the conditions are there, acquisition itself. As of today, no notification under section 8. And if I would go to the action, cannot under the scope of the act, any notification that excludes these lands as of now. Because the state government relied upon a judgment of one Thomas Patra. The learned single that is order, yes, admittedly under the PIA. But even if I got the learned single that order, even after the final notification section 8, the land is to the government, your encumbrance, but the acquisition is not complete. Therefore, they can invoke section 8, but they not. I would respect this. No longer hold the view of one country, nor the next longness enough. Only take the loss to some relevant. Not only take this synopsis. Once it is, of course, this has been held in a number of letters. This judgment I produced is in the S1 number 12 notes. So this is page number 8. That's why the vision went to this order. However, the see page number 30. See what issues were. Page number 13. First paragraph. Petitioner before us is following the
Patra's statement was not produced before us. Patra's judgment was not produced before this court. That's all, not produced.
This judgment, I would respect this. I would respect this, that this judgment holds the field for that to the extent of holding that after section 28 for notification. Acquisition is complete and land rests to the government of all encumbrances, and there cannot be notification after. But one submission for the sake of complete is that the first paragraph of the submission of the petitioner recorded. Then it started the notification proceeding to delete certain lands from the acquisition. Then what the state contended in. Paragraph number 4. Page 15 at the bottom. Responding state contains our extent of land for notified acquisition mentioning the detail of the survey number and the land detail of not concluded as the India tentative proposal depending on the proximate requirement of land required for the project will depend upon the alignment drawing to the border. You can take a filing such alignment drawing is not complete and current with the neighbor in the and the question of far away from identity they are not the so-called denotification came to be made only after thorough inquiry and consent to the states. And the consent project the denotification came to be received by exercising a power. Section 4 of the PIA. Section 21 of the Century Parliament. That was the submission made by the problem by laws to the analysis as to the provision. The law for the time is page 26. After all the subsection section 28. Paragraph 18 page 26. In the present case. In the present case, you have to see whether the land in question rests in the government, rests in the state. Or by operators, by PIA. Another case, Once final note is for the next one. And would have been notified after this. By work. There is another. Paragraph 24, page 31. But yes. Possession of the land and compensate once vesting of the land takes place, notify the land after completing the procedure as the state justified in issuing a notice under section 4 of the AI for division of the land from the entire. Then of course the division was to conclude paragraph 8. Even if the purpose for which the land was originally acquired for some reason, the land will not revert back to the owner, but best is state government. And the state can use the state to the public purpose, all of this is the usual public. Finally, the last notification. Therefore, assuming that state did advance submit on micro that section 28.4 does not complete the acquisition. I would respect this saying that the responsibility to order the dividend. In fact, the various other done for the sake of convenience have already produced fund. Then, the second aspect to answer Malaw's question has been the keynote. It is very briefly. And Noisian submitted all these days. And only taking a lot of a couple of days. In the preliminary notification on 29/1/2000. Then the ODP was notified on 12th of February 2004. That admittedly lands in question were required for construction of this, complete of this project. Then not admitted, sorry. Not admitted. It was admitted by myself. I'm sorry, I can't correct it. Then with the change in government and so on November 2006, there was a government order that is the entire alignment with the court. Now, interestingly, this one number immediately challenging the government order for because the alignment of the board was changed. Various grounds that was challenged. Interestingly, those who themselves in those proceedings. The impeded themselves proceedings. I would submit that now being advanced reform has been advanced already in those proceedings. And all progress with this only one volume I have one other court officer. So this is the first volume. Only volume one mother. Page 126 is the order. Meant by order date, second of April. Itself are released. Where is what? Government order will never be for this. Point out how the states are one case. parties. As per the agreement, as per the agreement, and you know, respond in survey number, not at all proposed to be alignment. Only because of the change in alignment. In the final notice, land belonged to respond. Survey number was not. It was also not yet. Then a senior counsel as per the alignment of land belonging to the purpose that is is at a distance of kilometers and is not at all required. The only endeavor in reading this paragraph is points out. All these things say is subject to the already been advanced for this one. Finding the page equal to 3. Submissions of the state and the current reform law. Just the last sentence of page 220. Therefore, the acquiring authority, after watching what the honorable therefore the acquiring authority is at liberty to proceed with the acquisition of the lands belonging to the complainants in CCC number 2. That is the appellate reform. As per the alignment of the the state that reserve liberty to proceed with the act. But they could have chosen to challenge this one. It did not choose the land. And it chose to do the follow. And it was then this is the part of this is the act. And on 2nd of September 2000, just about 6 months later, they issued the final notification to notify the subject. Therefore, I would expect the subject state after liberty was reserved. Once the state is chosen to acquire liberty, it's rather copy. That afterward, once again, I will say that the lands are not. I did not intend to acquire. Once one also has to be more long. Many years of litigation, of course, we understand why exactly the state has to do what it did. It's rather surprising. I will just stop it. But only one last point. As regards somebody, and it's not immediately. Submission of the evidence in 2004. There was a road network map, which according to the appellants excludes their land. That is shown the reversal. That is what the subject, which is why Mr. Nayan not admitted. But I think this is this is one example, page 254. The learned also, therefore, the state admits that the learned also the state submits that there is a difference in the road network map These are the land which is not in the ODP dated 12 to 2000, which they are already having considered. That's the decision. State also has noted they have made an error. Therefore, I would say this lies on the board is not going to be taken. State is noted. Another thing is the state, and again, we consciously chosen to notify me to entirely reflect the position of the state. That is a record. And there was another still currently final. Beyond that, I don't want to repeat anything at least. Like, how this is the find of the government. That already taken note of when on the Supreme Court is on the hand. Said it was after the change of mind on the part of the state government came about, coincidentally rather than change of the government in 2000. That has already been noted by like cost also. Therefore, I would recently something. Within the time, this is long-standing. Processing first will make the request is not even given directly to hand over in land. So it is not my way. I can't make it. Given the circumstances, was it directly may be required in this?
Kind permission would like to rejoin on the submissions not of the other side. I think submitted note, this case note has two contours. One, it is in the validity of the acquisition. Two is the rights of this beneficiary. I'm somewhat not intrigued and surprised by the submission that was last made by my learned friend, Mr. Vikram Hindor. He said that the court may even give a direction to them, to the state, to acquire, take possession, and hand it over to them. I think not, with due respect, that seems to be a most extraordinary submission and a prayer that could be made in a proceeding of this kind. It's not PIL, it's a purely private interest litigation. No, not my learned friend. I'll deal with the submissions of Mr. DL and Rao. Kindly take the submissions that he filed, just for convenience sake. The first submission he made was that Vijaya Leasing Limited is overruled. Now, I'm conscious of the decision of the Supreme Court. I was aware of it. In fact, I wanted to mention it to your lordships. What is the effect of that overruling? I'll now deal with it. Vijaya Leasing judgment, which I have submitted. In volume 7, that's the copy 7 sub number 2, the judgment of the division bench. Begins not at 4160. Not INR 2.5 Karnataka 2.39. You want to 169. Para 9. Second line. Consequent. State government acquired the land by a shortcut notification, withdraw the notification issued under Section 48 of the Act should be frustrated. After issuing the Act required again initiate proceeding but by issuing Section again. So the submission I made not for
state not acquire this land. If not lost, issue section 28. The ratio date here can be done substitute. They can be taken again notifies. They can again undo that as per is that they should have started afresh under 28.1. This land. They can't withdraw the withdrawal notification. That was what was the finding. That is in this compilation, additional list of authorities, page 1. And PDA versus Vijayalisi, 2013, SCC 737. The entire discussion law, whether the division bench was right or wrong in putting first single every single judge, the entire controversy brought was this was an decision under the Land Acquisition Act or the KAD Act. But the Land Acquisition Act section 48 says possession is not taken. Then you can pass an out notification. Kindly go to page 7, paragraph 15. At Placidum F. Minister. Page 7, Placidum F, which is paragraph 15.
This is something else.
This is about 2013 14 SCC. It's called the heading as additional citation. In that, kindly go to page 7. First element.
Yes.
Your lordship to get para 15.
Ah.
In that Placidum F. The conclusion of the Honorable Minister that possession continued to remain with the owner was contrary to what was found on record. The Mercer dated 9/12/83 has the judge was filed grievance that the conclusion of the Honorable Minister was expressly illegal and untrue. Say conclusion obviously appeared to have been made some ulterior motive and purpose and with a view to show some undue favor to the first respondent hearing. The accusation became finally conclusive. Asked for paragraph 15/771 when section 6 declaration came to be issued. At no point of time was there any challenge either in the investigation or the declaration. Even the award was not the subject matter challenge. So what their lordship correctly noticed, the Honorable Division Bench was in error in committing the conclusion that possession was not taken by the minister's visit. The minister paid a visit there. He said some shanty there and then shed is there. This is a reasoning law. Why the lordship say that the Honorable Division Bench is not sustainable. The observation is consequence. First, the ratio of the judge plot, the extent it is not reversed, is still valid at binding. But I'm finding a small compilation of 3 judgments. Division bench of the Honorable Karnataka High Court, Green Hill scale. But the controversy here, it was in a binding proceeding. The controversy was damages was claimed by the petitioning creditor. The defense was that damages are not taken till it's quantified. Then petition does not like. That was the controversy. They relied on Raman Iron Foundry's case in the Supreme Court. The Supreme Court said if claim of damages are quantified and agreed by a civil court or by arbitrator, it's not a take. Raman Iron Foundry not had 2 other points relating to interest. On the interest point, the Honorable Supreme Court first
Raman, and that was cited. Can you go to page 16? And in page 15, bottom, their lordships referred Raman Iron for this case. Then not referred to section 74. There's a note, my lord, at the middle of that. The decision Raman boundary continues to be law with regard to the principles relating to damages, even though it is dissented impliedly over on another point, HMP Ansari. So this point which I am relying on, as a matter of procedure, but submission is that the decision that I have cited is not on this point, and therefore I am not at fault. In fact, we were conscious of the Supreme Court decision, and I was aware of this principle. Unless the other side shows this observation is other side, that is not there. Now, Thomas Patrao has not been referred to, but not cited. I thought for completeness, it is there in the second judgment in the today's compilation. I would only not in this case, the peculiar facts of that case. What happened in that case was the land was notified. Compensation was not paid. The petitioner came before the court and said, you have acquired the land. You cannot stay to pay compensation. The authority said, you don't want this land. The argument was, no, you come find it back anything now, 28 court is over. We are bound to pay. And the next did not agree with that submission. Said, no, you state always has the power, the act. There's a long discussion. Page 40. 40. Page 39. 39. Paragraph 29. The above discussion is a entitled compensation, application of declaration and state government as provided in 28 by the Act. Owner is entitled to compensation. Yeah, right. And as provided in section 29. State government is empowered to land taking its possession by cancellation issued under subsections 2 and 4, section 28 Act, in exercise of power under section 21 General Clauses Act. In the event of the state government cancelling the application as an person interested in entitled to damages suffered by him, together with all costs reasonably incurred by him in the prosecution proceeding. Land acquisition officer shall assess the damages and costs as being done under section 48 Act. In this case, third respondent has issued an endorsement as per Annexure A, stating therein that the decision is taken from proceeding. Annexure B, the second respondent has resolved the legal land petition. State government has already issued notification 28. State has decided in accordance with 21. That's what exactly happened back is. So in this dicta, which not as not set us university, the judgment cited it would be decision. That is the issue not relating to when issue become final. And the act is the petition. That issue was discussed. Whereas at this point, God, I respectfully recommend starting is not enough. Right? Parties have acted in accordance with scale. It is for anyone as a collateral challenge. The judgment is impliedly overruled. Unless this issue arose, or the lordship said that it is not the correct legal position, they reverse case proceeding. Without that, what my submission is that this judgment will proceed. It is not it has been reversed. But in the judgment which Mr. Vikram cited today, Lord, the lordship doesn't mind taking that. I just want to point out one sentence of facts. What happened in the case? When we go to page 28, judgment lot of the division bench presided over by Honorable Justice Manjula Chelur. At page 28, just above para 20, last sentence. Now therefore, now the question is whether state government would have denotified these lands after they vested in the state by virtue of notification under 28 for the Act. Now, Lord, in our case, that section 4 notification which was issued was before the final notification. Nineteen 10/2007 is the date of denotification. The notification which is included in the writ petition is 9/2009. That's 28. Another factor what is, in the facts of this case, the acquisition notifications had been challenged earlier and they had been upheld. So the Honorable Court says this is the second round, not permitted. That is what happened. Now, what same argument is advanced here also, I will deal with that argument, not on second round, third round, all those things, but I will deal with that. But for that, may I just cite, since your Lordship has my place compilation, one judgment, a few sentences, as to how we should look at order. What is the cause of action and what is judicator? The cause of action for petition 356A and the contempt order which were read and also just now read was that there was a tank, the road was buried or around it. The base the petition said they don't allow it on stilts, plant was skirting around. That was the controversy there. The controversy whether this land in survey number 102 is needed or not needed, or the curved alignment. Decided by the not address itself to the question, okay, this the curved alignment, your land will be taken off. Was not a question that was decided which fell for consideration. But fell for consideration was the state and showed a stand around the take. Now, that was what was questioned. Whether that change could be made or no. The entire thrust of the argument was whether in the Town and Country Planning Act they have made this change. Whereas in the current petition, the cause of action is the 28 notification that is issued across this land after the proceeding. And for the rest of the history, not repeat any of it. It's the cause of action for this case. But if I was a party to another case, a PIL, or a private interest litigation, where I agitated that this should not be made like this, and the court decided in one way, that can be a judicator lot or super as I am concerned. This land was never the subject matter of any other proceeding myself. But in the judgment that I was referring to, at page 46 in today's compilation, cause of action, para 18, cause of action was defined, I do not read it, para 18 only, page 46. As the third Privy Council, today's compilation, which I have filed with 3 judgments. Starting with the grievance. The third judgment, the relevant Procedural 13, page 46. Para 18. As observed by the Privy Council in Bayana versus Manalana, the rule is directed to securing the exhaustion of relief in respect of a cause of action and not the inclusion in one and the same action of different causes of action, even though they arise from the same transaction. One great criterion is when the question arises as to whether the cause of action in the subsequent suit is identical with that in the first suit, whether the same events will maintain both actions. That's what they discussed two cases. Kindly then permit me to read para 21, last para in the same page. The courts below were there justified in order to put an application of the facts. Consequently, the degree passed to the plaintiffs for recovery of stand up. The appeal to that extension stand dismissed. But I am mixing up order 2, rule 2 and section 11 res judicata because they are not cited either of them. They didn't refer your lordship. So either section 11 or order 2. I'm assuming both of them are somewhat parallel overlapping. Order 2 is like the particular prayer on a particular cause of action. And I'm entitled to 3 reliefs. I seek only 1. I don't seek the remaining 2. I can't thereafter file another suit for that other 2 reliefs. That's order 2. Res judicata is I gone to the issue is the same. Parties have the issue. The matter is decided one way or the other. Then can I file another action? Applying tests for both these plot, my submission is that it has no application whatsoever. The controversy in the earlier case, I go to court at a preliminary stage, and the court says, why did you come into detail when you won't give reply and after we shall see? That cannot be res judicata. They are not even issued the final notification at that stage. Therefore, my submission is these two submissions not on the other side and merit in it, and will not put the merit rejection in my respective submission. Emphasis was laid by my learned friend in 2010 notification order. And what its effect is, what I have already argued for. My learned submission was 2010. The notification under 28, that was its main subject. So you cannot treat that as a rescission of 28 to acquisition notification. By that notification not issued under section 4, they withdrew these lands from the purview of the act itself. Not under 4, when certain lands have to be acquired, they have to be notified as part of an industrial purpose. If they withdraw it from there, then what my submission is that everything else that followed from it has to go. But I'm asking myself a question now. If supposing some 100 acres of land near a particular town is notified as an industrial area, they start acquisition proceedings, they finish acquisition proceedings for 90 acres. The remaining lots in the 90 acres, some portion of it, some reason they said there's a forest there, we don't want industrial area. So the issue of notification of section, say in the 100 acres we notified, these 20 acres we are deleting. That is not at all forming part of the land which could be acquired. Therefore, apart from some semantic jugglery, my respectful submission is the meaning and the purport of it has to be given effect. And that is, the government was very clear. And the only impediment they had, even published it, the impediment they had was there was a petition pending. They said subject. Subject to means plot. If the Honorable Court was to pass any order relating to this, then that will apply to this. Now, what did they order disposing of the case? Is they said skirting around the lake is okay, but now you find out whether these lands are needed or not. So that exercise will not was undertaken, and your lordships have seen a number of readings that took place, pointing out clearly by every authority except one notation of the chief secretary Each notation, my lord, does not take note of the preceding notation in the file. The directions, my lord, the observations made by the principal secretary of the PWD department, it doesn't take note of the affidavit subsequently, my lord. Several affidavits have been filed by them in judicial proceedings, taking a stand very clearly that this stand is not needed. My learned friend, Lord, in passing, Lord, showed a map and said, you know, look at this map. It shows that the ramp is to come there. It's operating for more than 10 years. No one said that this is the ramp there. And they are not producing the document. They look here even today. It's not complete. The toll is not complete. Not able to make a toll plaza. And this land is needed only for that purpose. And if it is there, say, that has to be vetted and approved by the Public Works Department, the nodal agency under the agreement. That's what Honorable Supreme Court said, my lord, in that latest judgment I placed for your lordship and consideration. Whatever may be your agreement, you go by the framework agreement, you have to follow the procedure, you have to contact government. If you've not got it, it's not there. You're orally showing a map, then saying, no, there's a categorical change. It's not very easy for us to argue that advocate did a submission before the court, there's a categorical mistake, therefore the land is acquired. What did they do with the cartographical change? The map which they showed, the lands which were wrongly shown is acquired, and with them they built the loop somewhere else. They completed the loop. Now this is some purpose which nobody has said anything about. Therefore, my lord, my submission is as a person, lord, the other argument is somewhat astonishing that stand acquisition be sustained, petitions, land will vest in government. But this land was notified pursuant to an agreement, framework agreement, project technical part of it with Nice Company. Nice Company entered into another agreement, agreed to pay the entire compensation. State doesn't have money, my lord, to acquire thousands of acres like this. It has to pay the compensation. Nice Company has to pay the compensation. They agreed for that. They didn't, of course, pay the money in due time, but they kept paying bits and pieces. Now, today, their argument is, okay, if I don't have to get the land also, it's okay. That acquisition become final. Will pay me the compensation. They are not going to pay because they are not going to get the land. Can the state acquire? They notified it for this purpose. Now, the state comes to the conclusion for this purpose, which is not needed. Then the argument of the beneficiary is, no, even if it's okay, it doesn't matter, let land vest, state can do whatever you want, it can set up a football player ground or something there. But they suspect I'm submitting, but it's an absurd argument. It's an argument, Lord, which has to be just stated to be rejected. The state is not here to acquire lands and keep it at the land bank somewhere. The state is now categorically before your lordship's court stating, and before Supreme Court also, not once, but innumerable times, stating that this is not needed, this was not part of the project. Now, not to say there is a chief secretary, on the basis of that, this final notification is issued. Let me assume, my lord, for the sake of argument, that the chief secretary did write a note of full application of mine with everybody in the project involved, including PWD secretary. Let me assume that. Now I am a citizen. I am challenging this land acquisition. I am saying, sir, this land is not needed. You wanted it for this project. Project is over. You don't need this land. Why do you want to acquire my land? Was my question. I posed all this before 28-3. And your lordships have seen the order, perfunctory order without application of mine. Now, when that comes to government, how did government apply its mind? The PWD secretary says that we never approved this. Chief secretary says no need of checking anything more, go ahead and acquire. And it's notified. Now, Lord, your lordships are reviewing it, judicial review. Whether the citizen's land can be taken in the manner in which they've done it. My respect submission word is this. Article 300A, Lord, is a very, very important right of the citizen. It was taken away from 19 as a fundamental right, but still remains a right under Article 300A to own property, right to property, as is my property. If they want to take it, unless your lordships are convinced in this proceeding that the state has applied its mind and the decision to acquire this property is justified on the material that was available before it. On land, are seeing what is the application of mine to anything that you have done here. How can we sustain such acquisition? You acquire it for purpose A and you don't use it. You acquire it for housing project and you abandon the housing project. Supreme Court in Mediation itself, JP Nagar 9th phase. Large number of 800 acres of land was acquired. They didn't do anything. 13 acres, we did some small thing. Honorable High Court has said, division benches have said this acquisition is lapsed. It can't be pursued because you didn't use it for the purpose for which you acquired it. Honorable Supreme Court has affirmed it. So, not the controversy in this case is not whether the land would be vesting and whatever they want. Then now the question is, they will say, state says, I don't have money to pay. In fact, that's exactly what happened in Thomas Patrao's case. The state, they found that the state doesn't need that land. Yes, we had issued a notification that we did. Now we are not going to pursue it. He said, give me compensation. State said, no, we don't have money. We are not giving you compensation. We don't need this land. We're returning it. So that's the question. The Honorable Court now came to this conclusion. But one letter, I'm sorry, I think it's only in Kannada. That page 897, volume 2. It's a rejoinder volume 2. Where the project, this project is administered by PMICP. That is PWD department, Public Works Department. They set up a small cell for this project. The head of that cell is addressing a letter on 19/2007 KIADB. But the role of KIADB stops at the stage of 28.3. Page 897. Rejoinder volumes. Rejoinder volume. As delegate, my lord, they issue the notification at 28.1. Thereafter, they hear objections. The Special Land Acquisition Officer, with his recommendation and his observation, sends it under 28.3 to the government. Thereafter, it is government which has to examine. In government, my lord, what happened in this case was, after the direction of the division bench permitting me to file objection and them to take a decision, they didn't take a decision. And I filed a contempt petition. In the contempt petition, they took a stand that no, KDB has done whatever. The division went into that question and said, it's not a question of KDB doing what it has to. Government is the one which has to decide under 28. And the secretary to government was implicated as an accused person in the contempt proceeding. The division bench court ordered this and directed charges to be framed. And in that, this analysis is there. It is government. 19/7/2007. 19/2/2007. I'll only read, Lord, sorry, Lord, I'll provide a translation of it. Karana, I'm reading at 898 last paragraph. ಕಾರಣ ಉಲ್ಲೇಖ 1ರ ಸರ್ಕಾರಿ ಆದೇಶದಂತೆ ಒಟ್ಟಿಗೆ ಕೆರೆಯ ಬೆಳೆಯ ಯೋಜನೆಯು ಪೆರಿಫರಲ್ ರಸ್ತೆ ನೇರ ಪಂಕ್ತೀಕರಣವನ್ನು ಅನುಷ್ಠಾನಗೊಳಿಸಬೇಕಾಗಿದ್ದು ಅದರಂತೆ ವಿವರಗಳನ್ನು ಪಡೆದು ಮುಖ್ಯ ಇಂಜಿನಿಯರ್ ಸೋ ಅವರ ಪರಿಶೀಲನೆ ಹಾಗೂ ತಾಂತ್ರಿಕ ಅನುಮೋದನೆ ಪಡೆದ ನಂತರ ಅಂತಿಮವಾಗಿ ಭೂಸ್ವಾಧೀನ ಪಡಿಸಿಕೊಳ್ಳಬೇಕಾಗಿರುವ ಸರ್ವೆ ನಂಬರ್ಗಳು ಹಾಗೂ ಕ್ಷೇತ್ರಗಳ ವಿವರಗಳನ್ನು ತಿಳಿಸಲಾಗುವುದು. ಅಲ್ಲಿಯವರೆಗೂ ಒಟ್ಟಿಗೆರೆಯ ಕೆರೆಯ ಬಳಿಯ ಪೆರಿಫರಲ್ ರಸ್ತೆ ಭೂಸ್ವಾಧೀನ ಪಡಿಸಲು ಕೆಡಿಬಿ ಕಲಂ ನಂಬರ್ 28(4)ರಂತೆ ಸದ್ಯ ಯಾವುದೇ ಅಂತಿಮ ಅಧಿಸೂಚನೆಯನ್ನು ಹೊರಡಿಸಬಾರದೆಂದು ಹಾಗೂ ವಿಶೇಷ ಭೂಸ್ವಾಧೀನಕಾರಿಗಳು ಕೆಡಿಬಿ ರವರ ದಿನಾಂಕ 2/2/2007ರಂದು ಕೆಡಿಬಿ ಕಾಯ್ದೆ 28(3)ರಂತೆ ನಡವಳಿಯನ್ನು ಹೊರಡಿಸಿರುವುದನ್ನು ಪುನಃ ಪರಿಶೀಲಿಸಲು The 28 recommendation needs to be revisited is what they are saying. The reason being that this alignment, it has to be approved by the Public Works Department. If this is not approved, in fact, they specifically say, don't proceed with 28.4. Because 28.4 will arise. Very perfunctorily 28 order is made. You can't go by that. That needs to be revisiting because you have to look at all these things. This is what is being said. No, this is in 2007. Then what number of notes your lordships have seen? We come now to the Chief Secretary's note of 31/8/2009. None of these things are even adverted to. Lord, Chief Secretary is Chief Secretary. But your lordships in judicial review, Lord, if it's found that the view that he took is not informed by reason, it is contrary to the earlier record, on the basis of which 28.4 is issued. Honorable Court not will protect the right of the citizen to say this accusation is not justified on the material that is before the court. We cannot say Chief Secretary will not 1 month before he retires, he will write a note. That will become final. Judicial review is only to correct errors of this kind. That's what happened in this case. So nothing much really turns on that note, because that was the mischievous note where I used that expression, without taking note of what had happened in the past. And very cavalier manner, when you go ahead in 28.4, we don't have to see anything. That's what the note says. When the agreement says this, when Supreme Court says this, when all the authorities say this, this note says do whatever you want. Just 2 pages before that note. Again, volume sub number 2. There is a note from the Principal Secretary to Government reiterating same thing. Note before the Chief Secretary's note. Well, I think not read para number 199 onwards.
Page, which
Page 4233. Volume 7. Para 197. Last sentence, para 197. The question was whether fresh proceeding has to be started or no. There appears to be para, it may read para 197. On the second issue of whether the proceedings have to be started afresh or from the point of section 28.3 also referred to the advocate. He has now clarified that we can proceed on 28.3. This seems to be at variance with Thomas Pakraw and leasing. And there is no need to start acquisition afresh. Next sentence. However, we have written to the Public Works Department to confirm the alignment. YD letters dated 26/9/2009, 16/7/2009, and 22/8/2009, for which a reply has not been received. This is the Commerce and Industries Department under which KIDB comes. It's the note on the basis of which the matter goes to Chief Secretary. And the Chief Secretary's note is next page. She was discussed. It was noted that only lands notified under 28 must be covered in the final notification, not any fresh alternate lands. Advocate General has given a go-ahead, issue final notification to 28.4. Further, it is also brought to the notice in meeting that one of the parties supports on the Supreme Court, no stay is granted. The party has also made point that since KIDB will be issuing the final notification in this case, with reference to preliminary notification earlier, there is no need for KIDB to once again ask for alignment of the good criteria. The earlier note was to the Principal Secretary C&I is that to issue a final notification, we need to satisfy ourselves on the alignment. PW has to give it. Rest of the correspondence, your lordships have seen, I don't want to repeat it. The other submission I've already covered, my lord, as to what is the effect of the observations made in the writ petition and the contempt relating to that poor ply of the Kotigere. That's a point on which Mr. Rao has addressed, my lord. I don't want to repeat anything. Then, my lord, this 12/2/2004, the submission I made was, even if you go by 12/2/2004 arrangement, this land is not needed. The only person who could not place material before the court as to whether no, my submission is wrong or is it correct is the government. And they have not said clearly now before your lordships that in that alignment also this land is not needed. Therefore, what is the purpose of this acquisition is a matter, my lord, which ultimately will be your lordship's kind decision. Now, Lord, another submission made was that I filed a SLP and I withdrew it, liberty to pursue other proceedings. If liberty is reserved and I have pursued other proceedings, I can't be without the main proceeding and without this proceeding also. And liberty is given the right to pursue everything that, because no decision is made by the court. Then my learned friend is trying to not distinguish the judgment which I cited 2020 SEC online. I don't think I'm going to spend much time on that. Your lordships have seen it to some extent. So the submission that I'm only making is this, Lord, in regard to this very project, in regard to the interpretation of the rights of the parties and there's a pronouncement of the Supreme Court, interpreting the framework agreement and the rights of this beneficiary, that decision, Lord, is the guidance as to what should have been done. And the state is now saying that it's not been done. Then, Lord, the series of writ petitions is what Lord submitted. Page 10 of his note, Lord, he refers. The first writ petition is 20729. That's the judgment, Lord, where this honorable court permitted me, that is Annexure E, page 119. I was permitted to file objections. Lord, there is a controversy. My learned friend says 3 weeks time was given, I didn't file within 3 weeks. Lord, the date of the judgment, if the lordship goes to first volume of the writ petition, it's at page 119. The date of the judgment is 18/11/2005. Copy was applied, my lord, at 122. The copying seal is there. We applied on 1911. We got the copy on 112. And my reply, my lord, to that is on 21. Annexure D2. The same volume, page 10. It's filed on 21st February, December. And this is considered. Say now, there was some delay, and therefore that should be eschewed record. Even if I did not file objections, I'm putting it at the other extreme. Supposing I had already filed one, I didn't file any additional. Government has to apply itself, not apply it. Which my directive refers to is 1487009 to restrain Nandi from going around the lake. I have already submitted, Lord. That lake case has been this. The lordship doesn't mind, my lord, seeing what is that writ petition about. 1487. It's, my lord, page 2392, volume 4. 392, volume 4. The where that writ petition, my lord, is at 394, the opening portion of the order. The main attack was that you changed this alignment without obtaining Ministry of Environment and Forest clearance. 239. Really set up 239. The remedy is by Article 26 Constitution. To direct the respondent authority to take action against R6 and 7 for undertaking construction of the road without obtaining approvals of alignment and design of the road as contemplated under the MPF. Date 8/10 by the annexure. So this cannot be a res judicata. This cannot be a bar. Now, I come to a question about suppression, sale of some land by me. I carefully went through the pleadings in the case. They did not raise this as a point. They did not argue merits. So not a point which was considered. Now also before pleading, it is made to stand for suppression. Actually, in this case, that in the earlier petition, they had entered into an agreement for 3 acres and odd acres of land with the developer. Actual sale had not taken place. Sale deed not taken. Sale was entered in. A GPA was given. In exercise of the law, developer not sold certain areas, that is 3 acres and odd. Now, if I am not ceased to be the one of these 3 acres, the only consequence that can be visited upon me that I can't get relief for the entire extent that I've sought because I'm not the owner of that. But it can't be my entire petition have to be dismissed. And the facts not are stated in the earlier writ petition, which is referred to in this. In this writ petition, there is a reference to the earlier writ petition. In fact, by NICEL, page 1315, it begins. 1316. They refer to this. That means they were before the court. They bring to the notice of the court this.
Volume.
Volume 2. Begins at 1315. That is portions 1316. What happened was in this statement of objections got filed for the first time in the writ appeal, because before the direct single judge, without issuing notice, the imposition of dismissal. For the first time before the sound of court in the appellate court, they find the objection statement of respondent number 12. Of suppression of fact. Some agreement has been entered in. Paragraph page 1316. Paragraph 3. The first mitigation. IDW. The first round of litigation. ID petition number 2079. They have admitted in para 9 that surrey number 1045 for 5, 6, and 7 were converted into various sites and sold to several individual purchasers by the various registered deeds. The particulars of the purchasers, etc., are furnished to the petitioners and annexed L to the said petition. No copy of the annex is produced. It's not a suppression, and therefore the repetition merited dismissal. That extent don't give them relief. I am conceding to that. The extent of sale, I am not entitled to relief. They find an memo in this interface with certain documents. To that we have responded to all. If the details of this, that memo was available at page 1520 in volume 3. And we have produced not the sale deeds. One 1520. Para in fact, in para 9 of it, filed by appellates, appellates have clearly stated that 3 acres, 13 acres, scheduled property has been sold before notification. Notification KDB have controverted, none of them have controverted the fact and accepted without them. And I given the details of the case. Practically, it is this company which is doing everything in this case. I showed you what is not the one document which showed an NOC being given, an affidavit I had filed in favor of some political personality who was an MP or something. I've stated in the affidavit also. Now, totally, my lord, 221 no objection certificates have been issued by this project company, asking KADB to delete lands. That entire list, my lord, is available. I produced it. Page number 574. volume number of lot is 4. Page 1945. Fine. Now the details. Lands were notified for acquisition. And KADB says we KADB says okay, denoted. Shock the conscience. With acquisition, practically All these are preliminary notifications issued. Before final notifications issued, go to my box. As per NOC. What is it? Okay, do it. Now sufficient. My then friend got had a day on words. Maybe it's later rain. It's good also. 3 1 3. I also refer to some other Kannada word which is rhyming with mantri, which I won't say. But the thing is this, not that this interplay of words is good in lighter vein. But in this case, there is no pleading that I had any agreement, no document showing any agreement I had with freedom. No correspondence, no payment of money, no other step taken. Now, if country developers writes a letter, say I'm thinking, negotiating with somebody, and the minister takes note of it. The minister, it is that letter which led to this order. Order was supposed to bind so many arguments of prejudice. Not try to prejudice the mind of the court, but even the person, the order of the minister is influenced by somebody. But there is no material, no pleading, but the respect request is testimony of that submission. So the party, if he takes responsibility, his client should file an affidavit and we know what to do after that against him. If he does not like that, council makes a submission, say 1 3 1 3 3. I also have to say the same thing. That's all. No material, no debate, not at any point of time. And but let's exclude this order of the minister. Why is it they have anything to say for that, except all these technical arguments? He has referred to section 21 at the end, the General Clauses Act. He has looked into the entire historical perspective of it, the background of it. Now, Lord, if that is not published because of pending litigation, now, Lord, the government is also sometimes in a fix. Damned if you do, damned if you don't. Matter is pending for court. If they do any action, court will say, you know, it was pending for court. Who asked you to do all these things? Then if you say, no, contempt action is not there, they may still say, contempt action is not there. You know, they are dealing with it. Now, if they do something, then also it's a, in this case, Lord, he did not, the publication didn't take place. That doesn't mean, you know, all is not that a publication is a consequential statutory requirement if it has to be gazetted for the purpose of financial. Otherwise, that's all. Very sorry, Lord, we have taken more time than what my sincere apologies.
No, your one sentence runs into 10 minutes. You give whatever you want. Oh, yes. Yes. But he stuck to the timeline. 2 minutes means 2 minutes. We use your one sentence completes in 10 minutes. You say one sentence. Madam, have you realized honestly enough, speaking for myself, did you realize what have you argued? What have you argued? All right, go ahead, go ahead. Just see what's the time, please see. Uh, that he told us that he clarified that it's not in this thing. But his this thing is all right. We'll all right. All right. You read it, read it. Yes. Yes.
I was assuming at the moment that government Karnataka having this one, I will dispute this parliament plan. This is a contractual dispute. This is a very all discussion whether within the 24 notification to instantaneously create a specified respondent number 12 to that affect the opportunity to come. That's why would be sufficient.
All gone. Huh? Huh? Oh, yes. You should be happy about this. Huh?
Not that I have given this of all the documents I have referred to for the age.
Yeah. Yes.
Page number.
Thank you. Yes. Good.
It's reserved, not.
Yes, yes.
Yeah, Acharya. Again, answer please.
Yes. Ah. That's why you are here. Yes. Huh.
or the negative is. And for the went to her, there is they told us, they give you one. It is separate. This is for separate or because they are being mentioned. This is also one. We also one. We not do question. We really go. This is the condition here. I want to contribute. Income was very common. The base said there and front said there open air there. And the post he has constructed there leading to the 7. 7. But the near end. 7. There is that is settlement. Settlement is drafted by a legal advocate. The document is given, I am not sure you are reading the document. Document. He says, and this document out of lower direction. Even when there was very controversy between them, not that word. Out of lower direction, the clearly mentioned in education, and that is what was the happening? There was a report and finally, The behavior and activity are totally different. In fact, can take it problem is there. I've taken her to some psychiatrist, the doctor, and give you some treatment, but no, nothing else is produced for the trial for which she was taking the treatment because treatment, nothing else is produced except oral statement. So this is the statement here. Now, then what changes? And 4 weeks of summer, this is the related date. 4 weeks of summer, 2008. This is the period. Let him take the boat. He saw that all his belongings was kept outside the house, kept in the open yard. And he was outside from the house. So this is what he said. This is his content. And the respondent sentence is on that day. Then got out of the house. The 4th of November 2008 is an admitted fact. But it can be admitted, it can be treated as you admitted. Because this sentence you are thrown. Other sentence, the 50. He has taken all the materials from the house, and he has left the house and he has started taking the transaction from them. Nearby. This is one thing not to today, they are separated. There were 2008. This is on the road of country and the here in case for you're not doing work and all this. And in paragraph 10, the specific content. Very different after you are about. As the board said, you want after
Para 10, where are you reading at para? Para 10, where are you reading? Petition correct. You are not reading it from para beginning. Para 10 says this respond. Yes, yes. Some people don't convey and refer that we will talk. Today's education is very casual and gradual and irresponsible, saying that you are married and the
All these new regulations we have made. And nothing has been produced before the trial court to substantiate this. It is one aspect which will be considered. And when the divorce has not been made, I have taken place in the earlier marriage. Whatever the marriage she has entered into, it is not recognizable under law. And she cannot approach it for divorce under the 31A and B. Then we another interrelation. What is the you and the student will talk about 100 kilometers. One hand. But if you have irrigation made, then you are the subsequent paragraph of all the delegations in different forms to be made. But here you examine the field, but here there is a difference. He has stated almost stated the same thing. In the cross examination, but the UHB ancestors are not the. But what he has stated is that so here the books is not created, nothing has been. And according to the examiner, the examiner brother, he said, the brother and son have destroyed his car. And they have created the company. Even that, right? He has the examiner. He has the examiner. So solution has been used. First examination, these applies are there, either you are aware about it. And you even major help, when you first examine, you were the leader. And when you were examine as people will see, the major. You will get the first examination too. And as far as the people, whether you also say, you are listening in there, and you have given all the suggestions. So just taking all this back and looking at what they are producing, the telephone bill. In the telephone bill of 4 or 5 days, she has contacted the second respondent. The second respondent is called with their content. That is during the daytime, office hours, and he was the head storekeeper. Necessarily, she must have called him. And one or two telephone calls, not everybody call the office or the subordinate. Really because he is a man and she is a man and she is female. You cannot take a delegation of this nature unless there is a substantial evidence. I'm not saying that there is no such possibility, but even to substantiate that, they must produce acceptable evidence. Sorry. The evidence available. Of delegation. But in this chapter, totally failed to prove this. I am not granting. The decision is there. No, we have to be the other process. Other part where you, whether it's there, a name of the decision. Other things are the limitation of the tax increase to pay. It will make up to pay but only tax. Why for the declaration last week? The position of the first point here is another position the first point. The data level, the page level, the meeting level. Page level. Number character, the number character. The meeting level, but the building for the additional and this. We are asking for favors on these two grounds. Please accept this is of the letter. Then we have to please come to have some page 12. Second amendment. This is the argument.
We'll continue tomorrow. Yes. See, Mr. I mean, if you don't face, then you are at set free. That we can make out from Mr. Acharya's face. He doesn't no fear, so he is free. No fear of losing the case, so he is free. Lighter vein, Mr. Nothing. Yes, Mr. Krishnamurthy Learning Senior Counsel commenced his submissions, however, on account of positive time, we saved on the concluded.
May it please the serial number 41. I am for the appellant.
Adjournment. Learned Senior Counsel for the appellant 41 prays for adjournment to enable him to prepare the case and argue the same list after ensuing winter vacation. Filed a memo, learned counsel for the appellant has filed a memo seeking leave of this court to withdraw the appeal. The aforesaid memo is taken on record. Accordingly, the appeal is dismissed as withdrawn. Huh? What? The respondent, Mr. Which said that case, right? We asked you. Same case, right? Maintenance. Right, counsel for the appellant prays for adjournment to enable him to prepare the case and argue this list after ensuing winter vacation.
Seal number 41, my lord, I think respondent's counsel who had moved the matter before my lords is not keeping well today. This may kindly be taken up after vacation.
Why let it be after vacation? What is the urgency? No hurry. Learn it. Ah. Yes. Learn it. Part heard. The matter shall not be treated as heard in part. Learned counsel for the appellant prays for adjournment to enable her to prepare the case and argue the same list after ensuing winter vacation.
Court officer. Court officer.
Yes, sir.
Serial number 41 adjourn ಆಯ್ತಾ?
ಹೌದು sir. After vacation.
Thank you.